First District Court of Appeals now in session. All who have business before this court, draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. All right, we have two cases on our oral argument docket this afternoon. We'll take them in the order in which they were published. The first case is case number 24-1319, AK Land Title versus Hurd. Appellant's counsel, if you're ready.
Thank you, Your Honor. May it please the court. Jessica Scholl on behalf of Appellant AK Land. I would like to reserve 3 minutes for rebuttal, please.
Noted.
There are a number of reasons that this court should reverse the trial court's holding that all of Lot B is encumbered by an easement and that AK Land cannot build a home on the property. I'd like to focus today on the first question, which is the threshold question, and I believe is dispositive in this case, and that is that no easement was ever created. Mr. Hurd cannot meet his burden of proof to demonstrate a valid easement was ever created because not all of the owners of Lot B signed the easement, and the owners who did not do so pursuant to a power of attorney. Lot B is owned or was owned by 4 couples, and only 2 of those 8 owners executed restrictive covenants in the first edition neighborhood.
And why didn't they have authority to do that from all 8, according to a power of attorney? And then we get into, I guess, the way that all 8 of them treated that disputed easement for the next couple of decades.
Sure. Even if there was a power of attorney that granted them the right to encumber the property, which there was not. There was a power of attorney that granted the right to sell and convey the property, and that was a specific grant of authority, not a general grant. So that's very strictly construed, and the court can't expand the powers of that. They're bound to the powers of that. But they did not sign the restrictive covenants as attorneys in fact. They signed, the notary block reflects in their individual capacity. Behind their name is the word trustee. That has no legal effect, and we cited several cases that to actually validly execute on behalf of the principal, you have to sign specifically as attorney in fact, and that was not done in this case. So one example is the Etheridge v. Palm Garden. That was a Florida 2nd DCA case of 2022 where they signed as responsible party rather than attorney in fact. And the court was like, okay, even if you have both of those capacities, you have to actually sign as attorney in fact. And that was not done in this case. The restrictive covenants state at the front, at the introductory paragraph, that they are being signed as attorney in fact for the property in the first edition. Lot B was not in the first edition, and that still wouldn't be enough. They have to actually sign as attorneys in fact, and that was not done. If you notice on page 30 of the record, the plat for the first edition states across Lot B, not included in the plat. So that's unequivocally evidenced in the record. To your question of, I think it's a ratification question as to how they treated it. We don't actually have any evidence in the record of how those 8 owners treated this. There's no evidence of their intent. And interestingly, there's really no case law provided by Mr. Hurd or that I found that you can ratify a property interest with anything short of the full formalities of granting an interest. And we cited...
Let me ask you about the bona fide purchaser argument, moving to a different area. Let's assume for a second that that they had the authority to enter into the restrictive covenants and that it's otherwise a valid easement. In your briefing, there's some reference to the bona fide purchaser status, and reference to the chain of title, that they're not reflected in the Lot B's chain of title for a good faith purchaser to identify the existence of the easement. Do you feel that you have preserved that argument below? Was that argument adequately presented to the trial court?
I do feel like it's preserved. I don't know that it's determinative in this case, but I do feel like it's preserved. I don't know how much more of a bona fide purchaser you can get than having a partition action seen all the way through. The court orders that the property be conveyed for value to AK Land. So, and that's what we have in this case. And so there was a full partition action resulting in a final judgment ordering the property to be transferred to AK Land for value. And we state that we did pay the value. He paid $145,000, I think, for this property in 2008. But I do want to hit on the ratification aspect because I think.
Well, so my question was whether that argument was presented to the trial court. And maybe you can point me to where it was. In looking through the answer and affirmative defenses and the rest of the record, I just don't see that argument being clearly presented in that way to the trial court.
So actually, Mr. Hurd asked for the trial court to take judicial notice of the partition action in the summary judgment response. So the trial court was fully on notice of those pleadings, and it was presented that AK Land purchased the value for property, purchased the property for value without notice of this easement. So I believe that was preserved in the lower court.
Is that enough to invalidate the easement just in itself?
There was never a valid easement.
Right, but my question is assuming there was.
Assuming there was, I think that the non-use invalidates it, and we go through that a good bit in the briefs, how there was at least a 5-year gap in use where there was no owners that were using it as testified to. So I think that for that reason it's extinguished. I think that it was clear that this was a purchaser for value without notice, that they purchased it pursuant to a court order, and that they were not on notice of any encumbrance. We know that the encumbrance was outside their chain of title. AK Land could not have found this alleged easement by a diligent review of the record. So as to the ratification question, I think what you're alluding to when you ask that this is kind of the way that they treated the property. The trial court found that the 8 owners were on constructive notice at the time they entered the trust deed. The trust deed does not reference, first of all, the easement at all. It's just generally we ratify anything that was ever done. And that is not, that's not adequate. That doesn't bring this into the chain of title. That doesn't place anyone else on notice.
Well, one of the things that was done, though, was restrictive covenant, right, that dealt with the use of Lot B for the first edition properties.
I do not believe that is specifically referenced in the trust deed at all. The trust deed just says, we ratify anything and everything y'all have done. It doesn't specifically say the restrictive covenants. It doesn't specifically say.
Well, I'm going off of anything that's ever been done. Why wouldn't that encompass the restrictive covenants that did include the fact that Lot B was for the use of, was
A couple reasons.
to be used by the first edition folks?
One, constructive notice is not sufficient. Again, ratification, we don't really see in a property context, right? Because you have to execute it with all the formalities. You have to identify the property and sign your name to it. And the owners weren't on constructive notice anyway, because that had been done outside the chain of title. Also, constructive notice is not sufficient, as this court held in Bach in 1979. It is generally the rule the doctrine of constructive knowledge does not apply to bring about ratification. The principal is charged only on a showing of full knowledge, not because he had some notice which should have caused him to make inquiry, which would have then brought his attention to it.
When you see reserved in capital letters on the plat, does that mean anything?
It has no legal meaning.
And so none of the properties that were platted on that map had reserved except for this one, which has reserved in capital letters. Is that something so your position is that that's something that can fairly be ignored?
I don't think that that puts you on notice of an easement to be granted in the future. I mean, the plat in 1957, the first edition, or the Evergreen plat, yeah, it had reserved, but it could be for what? For another neighborhood, for somebody to buy later?
Well, I think that's the question, right? For what?
For any-
It seems like there at least puts you on notice that something is going on with this particular piece of property. Let's find out what it is.
The fact that it was reserved in 1957 doesn't tell you today, when you buy it in 2018, that there's anything wrong with it after you've conducted a diligent search of the chain of title. You've bought it pursuant to a partition
Well, you
action.
find that it says reserved through your diligent search of the title, right? That's part of your diligent search. So you see that it says reserved, and does that put you on notice of something that there may be something more that you need to look into?
No, but I agree that you would see that it said reserved, the original plat, but a lot has happened since then, right? You follow, okay, now I see what actually happened, not to mention a partition action. But even if there is some, again, I want to hit on the ratification, because at the time that they signed the trust deed, you have to show actual intent to ratify this specific action at the time that you ratified it, when they signed the trust deed. There is no evidence in the record at all that those 8 owners had knowledge of the easement at the time they signed the trust deed. They couldn't have even had constructive knowledge, because that was, there's an argument about time. I'm not on constructive knowledge of your deeds. Just because they were recorded prior in time to the trust deed, a property owner isn't held to be on constructive knowledge of all recorded items in existence. This was outside the chain of title.
So why do you have this idea in the Marketable Title Act of use? I mean, you wouldn't see that someone has been using a property in a certain way at all in the documents. And so what I'm hearing from you is this is purely a document thing. But also, there's a lot of argument about, well, there's also this thing called use, and if someone has been fairly using an easement all along, then, well, that does encumber the property.
If they meet all the requirements of that MARTA exception. Adverse possession was not pled here, so we're not on adverse possession. I do think this can be resolved purely on the documents. And the last point that I want to make on why there was no, when the restrictive covenants with Lot B, beach easement were made, they did not sign as attorneys, in fact. I mean, that's just determinative. They signed as trustees. Okay, so we don't have a valid conveyance there. It's just 2 of them just signing as trustees of what they don't say. So it was not transferred. It wasn't ratified by the trust deed. There's no evidence in the record at all that they knew at the time they signed the trust deed, and constructive knowledge isn't enough, but they weren't on constructive knowledge either, that easement. They didn't even know of that easement. There's no evidence, okay? And then the trial court referenced plaintiffs' exhibits 6, 10, and 14. And so I just briefly want to touch on that after the trust deed, all of these 8 owners are somehow accounted for in subsequent deeds that grant first edition property subject to the restrictive covenants. Again, the ratification has to occur. We don't really ratify property interest, but the ratification has to occur at the time of the trust deed. And I want to point out that 2 of the owners did not even sign those subsequent deeds. Barry and Patricia Allen never signed any first edition deed in the record referencing the covenants. So those subsequent deeds were after the trust deed. It doesn't have anything to do with the intent at the time of the trust deed. And think from a dirt law title perspective, how could we know? I mean, I guess we can just all we ratify anything that's ever happened before. How would that ever put anyone on notice of the chain of title? And so for other things this is a wild grant outside the chain. That would be contrary to our recording statutes, contrary to the whole concept of a chain of title. If you could just generally broadly ratify something without specifically stating what that is.
None of that's in the chain of title for Lot B anyways, right?
I'm sorry?
None of that is in the chain of title for Lot B anyways. When you're doing a diligent search and you're going back through the chain of title, you're not seeing any of that stuff anyways.
Correct. You wouldn't see the easement in the restrictive covenants. You wouldn't see these subsequent deeds to the first edition. But even if that was somehow constructive notice, you're still missing 2 of the 8 signatures, the Allens. And so for that reason, not all the owners joined in any easement, and there was never any easement created. And that is determinative. And so we don't have, the continuous use question, I think, is an interesting one. The statute says, for so long as the easement is used. And so if you've got 5 years when it's not being used, and I appreciate that this court had held in Jacksonville v. Horn, well, it doesn't have to be continuous in that sense. But here you have an actual break in ownership where there was no witnesses. And also in Jacksonville, it speaks a lot about this exception being, for the public. Once the public interest is acquired, it's not easily lost. Here, you have private owners, and it's a different type of use than it would be a road or an underground utility. I mean, they were saying, this is to be used consistently. So I think that break in use would be sufficient. Also, finally, this easement would deprive the owner of any reasonable use. I mean, they just said you can't build a home at all anywhere on the property. It's over an acre. You can't build a seawall, even though the neighbors have seawalls. And that there was testimony that a seawall was needed in this case to actually save the property itself. And so that is not someone that, it's a residential neighborhood, a residential piece of property, and to say that the owner of the property can use it only for the same uses as the easement holders to go to the beach, that is a complete deprivation of reasonable use in this case. So I think the court has a couple of ways to reverse this, but the cleanest, in my opinion, is that there was no easement created.
Thank you, counsel.
Thank you.
And if the clerk would add 2 minutes to each side's argument time. Thank you.
May it please the court, I'm Steve Traylor. I have the pleasure of representing the appellee, Donald Hurd. The court issued a long, detailed, 21-page judgment that addressed all of these issues. In reaching that, the court considered 9 witnesses, 52 exhibits over a 2-day trial, and made detailed factual findings. I want to address first some of the arguments you just heard. I disagree that the whole bona fide purchaser for value issue is preserved. There's not pledged an affirmative defense, nor can it be. The Lot B has the word reserved in all capital letters across it on the face of the plat.
Meaning you think they would lose even if it had been pled?
Your Honor, I believe that argument is not preserved for appeal, but it's incorrect. They're at least on inquiry notice. Cases tell us there's 2 kinds of notice: constructive notice, which is legal inference that arises from recorded instruments, and implied notice that can be either, actual notice. It can be either express or implied. Implied notice is a legal inference from the facts and circumstances. Here, all of the applicable documents are in fact in the chain of title. That's just an examination that looks at what occurred during the period of time an owner owned the property. When you acquire property and when you sell it, between those 2 points in time, that's a link in the chain of title. All of these instruments are recorded while these owners owned this property. They are, in fact, all in the chain of title. In fact, one of the exhibits at trial, Plaintiff's Exhibit 15, is in the record at 762, is a copy of the general index from Santa Rosa County official records. It shows the warranty deed from the Dodds, and this is a page that pertains to the Allens. That index is alphabetical. The warranty deed from the Dodds, the power of attorney, the restrictive covenants, the trust deed, and a subsequent deed are all on the very same page of that index. It would have been found because it's recorded while they own the property, as that demonstrates.
And how you would get to that again would be a name search, you said?
Yes, sir. If you someone was searching to see what occurred, they would go to the general index. It's a direct index or reverse index. The names are opposite ways in the reverse. The page identified that's in the record at 762 is the direct index. And you can see all those instruments are recorded during the time where after the Allens acquired an interest in the property from the Dodds.
So are you suggesting that a diligent search would include searching for any other instruments that may have been conveyed or may have involved the owners
Yeah, yes,
by name, so that a diligent search would include looking at everything else that they own and everything else they've done?
Yes, sir. For example, someone may have a judgment against them. That judgment doesn't reference any particular piece of property. It's just a judgment for money. But if it's recorded, if I have a judgment against me and it's recorded while I own a given piece of property, it is in the chain of title to any property that may attach to, notwithstanding the fact that some particular piece of property is not identified in that money judgment.
Is there any legal significance to the word reserved in a plat?
I believe the fact that it says it's reserved would put someone on.
You believe, or there is legal significance to it?
Oh, there is a legal significance, Your Honor.
And what is that? What does reserved mean in dirt law?
Well, what the cases tell us, in fact, one of the cases discussed in the answer brief, in the chain of title section that's talking about notice, it says that implied notice is what arises from the circumstances of the case. Something would trigger you to ask questions, to investigate further. So seeing reserved across the face of this lot on the plat would trigger someone, or should, it's a legal inference that it would trigger
So the
that.
word itself didn't have any particular significance, but if you see something different about that square versus all the other squares on the plat, could be an X, could be an O, could be anything.
Yes, sir.
There's
In fact-
something different, and so that triggers some responsibility.
And in this particular circumstance, as you noted, most of the lots in that Evergreen Shores are identified by numbers. This lot is identified by the letter B. There's another lot on the far end that's identified by the letter A. It has nothing to do with this dispute. I want to circle back to the issue of the trustee. They signed the restrictive covenants. It references a power of attorney in the first paragraph, and it references a recorded power of attorney. But they added the words trustee after their names. The plat of the first edition is also signed by Mr. Townsend and Mr. Allen as trustees. So they platted this property in capacity as trustees, in addition to these restrictions as trustees. There's no evidence in the record that demonstrates that they did not have authority to do that. In fact, there's a tight window of 2 months from February 23rd of 1957 to the date of the restricted covenants on April 25th of 1957, where these couples acquired deed from the Dodds. The power of attorney is recorded on March 1. The plat's recorded as trustees on April 9th. And the restrictive covenants those are the dates of those instruments. I believe I misspoke. And then the restricted covenants are dated April 25th. And as the court's noticed, these owners proceeded to sell property in the first edition that references these restrictive covenants. The court considered a marketing piece that witness Clarice Kell received from Dana Dodd that references this lot being dedicated for beach use. Court noted that the developers sold lots with the representation that this lot's available. There's testimony that owners purchased that with that understanding. In fact, Mr. Hurd testified that he learned of these restrictions when he first bought a piece of property from his grandfather in 1980. All the witnesses testified to use of the beach. The court considered other instruments that are recorded whereby some of these owners either granted deeds in the first edition with reference to the restrictive covenants. Those are accounted for in plaintiff's Exhibit 15 with respect to one of the Allens, Patricia Allen. She and Barry Allen bought property in the first edition by way of a deed that references these restrictions. But certainly, any grantor is stopped from denying the things in a deed that they grant, as these owners would have been with these deeds that they granted with reference to the restricted covenants.
Let me ask you to shift gears and talk to us about whether or not, assuming it's all valid and this easement is as the trial court found, tell us why it doesn't deprive them of any reasonable use of the property.
Your Honor, what the court's judgment says is they can't do two things. They can't do three things. They can't build a house, they can't build a seawall, they can't do something that interferes with the use of the property for beach activities. Court noted that AK Land Title, its owners, its employees, guests can use this property for beach privileges. The court noted it can build a pavilion, volleyball court. They can do all these same activities that the lot is.
And why couldn't they build a house? I mean, it's a big lot, it's over an acre, and it seems like, you know, you go to the beach in the Panhandle and you have access on a boardwalk and there are houses on each side and things are pretty tight.
Yes.
And so that a house on a quarter acre, a house on a half acre on this lot would seem like, okay, this house is up in the wooded portion, upland.
Yes.
And you still have all the beach stuff going on beachside, you can still have a house. Why isn't that workable?
Your Honor, one of the arguments that AK Land Title advanced was that it's all or nothing.
Say it again?
That it's all or nothing.
Yeah.
If the beach,
Okay.
if it's encumbered by easement for beach activities, the entire lot. AK could have argued that very argument. Of course, the east 27 feet of this lot is also encumbered by drainage easement, but AK could have made that very argument and argued that some upland portion would not have interfered. In fact, the judgment acknowledges AK Land Title's argument and says the court agrees. That was the argument that AK made, that if it's there, it encumbers everything. The trust.
Right, so the trial court agrees. Does it not create a problem that they have this piece of property that is, arguably like a public park now that they have to pay the taxes on, and they have to pay the maintenance for, and they have to deal with liability insurance and things like that for these other people, but they're unable to do really anything else with it?
Your Honor, in fact, in the partition action, that judgment notes that Lena Allen, who's AK Land Title's grantor, had in fact paid the taxes for 17 years. And the distribution of those proceeds reimbursed her for that. But the land cannot be used by the public, and that's a distinction here. If it could be used by the public, then there's a statute that provides some immunity for an owner that makes his land available to the public. But that's not the case here. To make this available to the public would be greatly expanded, and I suggest overburdening the scope of the easement.
So who wants to own a piece of property that they have to pay the taxes for and insure and maintain so that a neighborhood can use it for beach access? I mean, does it realistically still give them the ability to use this piece of property for anything else?
Well, it arguably nothing inconsistent, certainly, with that. But there are, the court, I believe the judgment even suggests that this property could be sold to some owner in the first edition or some group of owners that may have an interest in becoming the owner or setting up an HOA. It's regrettable that there wasn't an HOA, but that's not what these owners did, because that's typically what would be done when there's common areas and you have mechanisms for doing those very things. But with respect to that, I suggest AK's land titles remedies lay elsewhere. It lay with going back to its grantor, or, something besides depriving Mr. Hurd and any other owner in the subdivision with the rights that they had long held and long used. The trustee found that
Well, what does that look like? Can you elaborate on that?
I'm sorry, what?
You're suggesting there's an alternative remedy. Tell us what that is.
It's cited in the last page of the answer brief. Asked Mr. Hurd at trial, Mr. Avant, AK's witness, its manager, if he had, and I'm paraphrasing certainly, if he had pursued going back against his grantor. And he testified to the fact that he got with the title insurance company about that. I don't know what transpired, he didn't elaborate, but his remedies lay elsewhere. His remedy is not in depriving these owners of their rights because he bought a piece of property that's encumbered by a beach easement. The trust deed speaks to ratification, approval, and confirmation. I submit those are three different things that are somewhat similar with respect to approval and confirmation. I submit by using all three of those words, the trust deed intended to say, whatever Mr. Allen and Mr. Forrest have done, we're okay with it. Ratification typically applies to some unauthorized act. There's no evidence that they weren't authorized. In fact, the plat, as I mentioned, being signed as trustee suggests that they were in fact trustees and were acting pursuant to some trust arrangement or agreement. This court's decision in Bach versus Florida State Board of Dentistry, 1979 case, is quoting the Oxford Lakeline versus First National Bank. It's a 1898 Florida Supreme Court case, and it's discussing ratification. And it mentions several circumstances. One of that is the last one that's cited in this court's decision, quoting Oxford, is that the person ratifying intended to adopt the unauthorized act at all events under whatever circumstances. So I suggest that ratification would pertain to some unauthorized act, whereas approval tends to denote that they're agreeing, they're acquiescing, they're validating. Confirming suggests that they're acknowledging or verifying something. So by using all three of those terms, and ratification is certainly a legal term of art that's distinct from approved or confirmed, I suggest that all of the owners is saying, whatever these two guys did, we're okay with it. And their subsequent buying and selling lots, marketing lots with this beach privileges as amenity demonstrates, and additionally that they absolutely were acting with authority and that these owners all acknowledged and agreed to that. See, I'm out of time. I'll stop.
Thank you, Mr. Trent.
Thank you.
Ms. Schul?
Thank you, Your Honor. Briefly, so actually the plaintiff advanced the argument of all or nothing. That was as early back as the complaint when they asked for a temporary and permanent injunction preventing AK Land from building a house on the property and saying that, just because we only use part of it doesn't preserve the whole easement. So that was the argument that AK Land was kind of forced to deal with. Hurd states that he first learned about these restrictions in the 1980s. Well, then why wasn't he concerned when it didn't say subject to the restrictions on any of his deeds? And that's at record 1042 and 696. Reserved, even if the word reserved, again, Just because it was reserved for some purpose in 1957 doesn't mean that you're on notice now in 2018 as following a partition action and the trial court scrutiny. But let's say it did. Let's say that that put AK Land on notice that they need to go and look for something. They could not have found it. No diligent search. And we even had an expert affidavit at record site 132 that said a search didn't turn this up. No diligent search could have turned this up. So just because you are even on notice that you need to go and look for something, that doesn't mean wild deeds outside the chain of title. I don't know who searches the grantee index just periodically for their own name, but so, okay, it's on the same
You may
page.
briefly conclude where.
Oh, Your Honor,
over
yes,
time.
thank you. The marketing piece has no legal effect. The easement never attached to the property. It was not able to be found. And for this reason, because not all Lot B owners made this representation as stated in Burdine, that it has to be the same formalities, there was no easement ever created, and for that reason, the judgment should be reversed. And I appreciate your court's time in allowing us extra time.
Thank you. Thank you, counsel. All right, and we'll move on to the next case. All right, our second case this afternoon is case number 24-28, Carmona versus Stocking Management, LLC. Appellant's counsel, when you're ready. Did you want some help with the podium there? Do you want to raise it?
I think I can manage, thank you.
Okay.
Good afternoon, Your Honor. May it please the court. Mike Weiner here from Tampa, Florida, on behalf of the appellant, along with my counsel, Mr. Skolko, who's watching online. We'd like to reserve 4 minutes for rebuttal, please. We are asking you to reverse the decision of the judge of compensation claims for three principal reasons, and to hold that under the particular facts of this case, that an employee is entitled to rely on the presumption that was discussed in the affordable plumbing case, that the employer has reported wages at least until he is allowed under IRS guidelines and rules to report those wages on his own. We assert that the judge erred for three principal reasons. Those include the fact that he did not properly apply the presumption that is set forth in affordable plumbing. Number two, that essentially it's created an impossible or act for the claimant to file wages or report his income to the IRS before the calendar year is up. And I want to discuss the facts of this case just for 30 or 40 seconds because I think they're very important. And last but not least, we also assert that the legislative intent behind Chapter 440 governs the application of this case and the outcome that we suggest. The facts that are particular to this case is that the claimant, we understand, was born in Nicaragua, came to the United States, and began working at Stocking Management in 2022. We know that on March 31st, he has a compensable accident, and that as a result, he meets all the other requirements for the payment of lost wages. He's not at maximum medical improvement. He's got restrictions which prevent his past relevant work. The judge of compensation claims determined that based on his actual earnings, which were paid to the claimant, actually directly deposited by the employer into the claimant's bank account, his average weekly wage would have been $803.06 per week, but for the application of Section 440.02. The claimant then is not receiving any benefits. He files two petitions, one in May, one in August, and the judge of compensation claims holds a hearing and renders an order in November of 2023. This chronology is very important. Why is it important? Because The employer, it is established as a matter of undisputed fact, did not do what they were supposed to do. The employer violated the law. The employer could have and should have reported his earnings to the federal government, to IRS. They didn't do that. So the statute, obviously, payment of wages, says that wages need to be reported. Does not say by whom. Affordable Plumbing suggests, and we urge this court to hold, that there's a presumption that attaches that the employer has done that. But in this case, the nuance is that the claimant could not have done that himself by the time his final hearing occurred in his case, right? You can't file a tax return. He could not file a tax return for the calendar year of 2023 in November of 2023 while the year was still going on. The IRS doesn't accept that. We've referenced IRS publication number 509, which sets forth the calendar year for which employees are required to report, and it simply requires that employees have to do it by the 15th day of the fourth calendar month. The claimant was never given a chance to do that here. So we see a couple of doctrines, and we've talked about the impossibility
What
of
import,
this.
if any, do we take on the fact that claimant has never filed an income tax return? So there might be a presumption that the failure to file an income tax return suggests that they aren't reporting this income regardless of what the employer is doing.
Doesn't matter, quite frankly. What he did or didn't do in 2022, didn't do in 2021 is totally irrelevant to the outcome of this case. We know that, at least based on the record evidence, he didn't make enough money in those years to file income tax returns before, right? The IRS has certain thresholds that if you're single, you have to file an income tax. We know that based on the record evidence that we have in the case, he never made enough money to do that. So I would submit to you that was a red herring argued by the appellees and found by the judge of compensation claims that has no input on the outcome or proper determination of this case.
So is your argument basically that this provision under the wage definition basically should just be ignored by courts? Because if I understand the rule that you're asking us to adopt, basically just ignore it because there's this presumption that it's always in effect.
I want to narrow what we're asking the court to determine in this case. We're not asking you to ignore the requirement. We're asking you to read into the requirement something that is consistent with what the IRS regulations contain. That is the when, right? Chapter 440 tells you simply the what. The claimant has to report. The when is dictated according to the Internal Revenue Service, right? So the claimant can't file his tax return in November of 2023 before the calendar years. He can't report those wages. So the presumption should at least attach until such time as the claimant is given legally the opportunity through IRS regulations to report that income on his own.
Do we know much about when this presumption should or should not attach? I mean, here, for instance, we know that claimant didn't give any identification to the employer. Claimant didn't give the employer social security number, I guess taxpayer ID number. Plaintiff never filed an application for the job. So the employer basically had no information about this employee at all. And to the extent that a presumption, you would guess maybe a presumption should apply if I receive a paycheck stub every couple of weeks from my employer and it says there's been a deduction for federal tax purposes. Yeah, I think absolutely a presumption should attach that they're actually following through with what they should tell me. Under the conditions here where none of that is in play, should the presumption apply?
It should, and I'm going to tell you why. You've only looked at the part of the equation from the claimant. The other part is what the employer knew all along that he did not have the appropriate documentation. The employer knew all along that they were contracting to hire somebody and pay somebody wages who did not have the appropriate social security number or anything else, right? So the
But he knew
employer
that too,
buried their
right?
head in the sand.
He knew that too, right?
Both sides
They
knew
both
that.
knew that.
They
right?
both knew that.
So to the extent there's a presumption, he also knows that he hasn't provided the appropriate information, that he's not authorized to work in the United States, and he doesn't anticipate that this income is going to be reported, right?
Well, I don't think that he knows that because, you've got somebody here who's obviously unsophisticated in the ways of what, requirements are under the United States law versus an employer who is at least should be presumed to know what the requirements are in terms of properly reporting taxes they pay, because they're paying out salary. So, again, the employer under federal law was required to report those wages. They come to, to this equation here with unclean hands. And,
And both sides do, right?
And I
I mean,
think
you
that-
would be in a lot stronger place if you were to file an application, employer had all of his information, his name,
Yeah.
his address, his social security number, and given him a check stub that said they were actually taking money out of his check.
Yeah, I can't.
That would give you a pretty.
I
good
can't
chance.
argue that. I mean, if I could go back and recreate the record, of course, I would do that, but we take the facts as they are in this case. And the facts as they are in this case are quite simply that the employer, presumptively should have known that it was supposed to report those earnings. They didn't do so, and the claimant should be allowed to rely on that presumption. I've got kind of three reasons why. We've talked about the impossibility of things. One of the things also is that, as I mentioned, the IRS regulations control the how you do it and when you do it in terms of reporting, right? The statute only says you have to report the wages, but you have to consider the IRS in terms of how and when. And the when does not occur until the end of the calendar year. So the claimant here has never been given the opportunity, right? So one of the cases or concepts this court has endorsed in prior cases is the law does not require a futile act, right? In this case, it would have been futile for the claimant to have filed taxes in 2023 before the end of the calendar year. Can't do that. The other is the doctrine of impossibility. We know that applies to contract law, but we're seeking a similar extension of that doctrine of impossibility of performance as it pertains to a statutory requirement, right? The claimant is not able, it's impossible for him to file a tax return that the IRS will recognize as earnings that are being reported until the calendar year concludes. And, we also had but it was done belatedly today, and I apologize for that, but I've been sort of grasping for a way to better articulate this concept of impossibility that has been put on page 20 of the brief. And there's a Supreme Court case from 2011 called Pliva versus Minison that talks about where state and federal law conflict, the state law must give way. And we have a conflict here, right? We have an inherent tension between the requirements of reporting of income under state law in order to make the determination of your average weekly wage. And the federal law requirements would say you don't get to report that until the end of the calendar year. The case goes on to say that when the conflict exists and it's impossible to comply with both state and federal law, the federal law governs, right? So the federal law should govern here. And the question of impossibility, if a party could independently do what the state law requires of it. So the state law seems to require that the claimant file his taxes in 2023, right? That's what the definition of wages seems to imply. He cannot do that. And so under the doctrine of impossibility, we would suggest this is the proper outcome that Your Honor should reach in this case. Now, there's another reason why that I think is critical, and it's been discussed significantly in the brief.
Were we correct to call it a presumption? Because it sounds like you're arguing, no, this is actually a lot stronger. This isn't a presumption, this is a rule that it's on the employer and you can take it to the bank.
Well, no,
as opposed to calling it a presumption.
I think what we're asking for is simply a presumption that exists until the time when the employee is allowed legally under IRS regulations, which according to publication 509 is the 15th day of the fourth month of the following calendar year, right? He gets that presumption until that time. If the claimant does not report his earnings to the IRS by then he's SOL, out of luck, right? But that's what we're asking. And I want to just touch quickly upon the legislative intent, right? Because there's an inherent tension that exists between the reporting aspect and between what the legislature has told you how you are to construe the statute, right? So what do we know? We know that it is the intent of the workers' compensation law to assure the quick and efficient delivery of benefits to the injured worker. That same concept of giving benefits to the injured worker promptly is repeated again. It's twice. It is an overarching legislative edict that tells you how you should construe this reporting requirement. And if you fail to construe the reporting requirement in the manner that we suggest, and at least give the employee the opportunity before the 15th of April the following year to report those earnings, then you have frustrated the entire purpose of the prompt and efficient delivery of disability benefits
Would your case
to the
be
injured
stronger if you
worker.
would have supplemented the record along the way with his actual filing?
I don't know that I could, I don't know that I'm permitted really to supplement the record once the record is created with something that is created after the fact. I mean, it'd be one thing if this had happened during the proceedings and it was omitted by the reporter in certifying the record to your honors, but I don't know that the rules allow me to take some document that has been a piece of evidence that's newly crafted after the final hearing has already been rendered and say, here, look at this. So I don't know that the rules allow me to do that. I'll yield the rest of my time for rebuttal. Thank you.
Thank you. Police Counsel, proceed.
Thank you. May it please the court. My name is Allison McInvale, and I represent the Appellee Employer Stocking Management LLC and its workers' compensation insurance carrier, Florida Citrus Business and Industries Fund. Your Honors, this is a very simple case about a very simple statute in 440.02 subsection 40. As to the definition of the word wages in establishment of an average weekly wage by demonstrating that income was both earned and reported for federal income tax purposes. What brings us here today is to determine whether the judge of compensation claims correctly applied the plain language of the statute, specifically the words reported for federal income tax purposes, and the prior decisions of this court, of which there have been many. What we should not be here for today are policy arguments presented by appellant, because those matters are better addressed to the legislature. This court has held in Fast Track Framing versus Caraballo that the phrase reported for federal income tax purposes is very clear and unambiguous. It conveys a clear and definite meaning. The legislature has given the judge of compensation claims a very simple test. Either income was reported for federal income tax purposes or it was not. That's all and nothing else. This court has already determined in 2020 in LSG Sky Chefs versus Zantea that the plain language of the general statutory definition limits wages to those that are both earned and reported and nothing else.
What shall we do with this idea of a presumption from the affordable plumbing case?
I disagree with appellant's reading of the Garcia-Lopez versus affordable plumbing case. I do not believe it created a legal presumption. When you read the holding of the case as a whole, the court was just elaborating on the finding in Fast Track Framing versus Caraballo that held that an employee must report for federal income tax purposes. The Garcia-Lopez versus affordable plumbing case simply stated that it need not only be the injured worker who has to report for federal income tax purposes to meet the definition of wages under the statute. The case notes that if an employer reports the earnings for federal income tax purposes, that would also satisfy the reporting element of the definition. I think that's as far as the Garcia-Lopez versus affordable plumbing case goes. An appellant seems to suggest that if there is a presumption of employer filing, then an employee can rely on that presumption that an employer made a reporting, and if there has been no reporting by an employer, then he's somehow excused from making a reporting himself. And in this case, under notions of estoppel, which clearly don't apply in this case.
What are the situations in which an employee could rightfully rely on a presumption that the employer was paying the taxes?
Well, I think as to this case, Your Honor, you raised a good point earlier today. I don't know how appellant could expect that a reporting would have been made because he knew he didn't have a social security number. He knew he didn't have a taxpayer identification number. He knew he wasn't documented legally to work here. So I think in this particular case, I don't think it follows that there would be a presumption that the employer paid withheld taxes. In fact, the appellant testified that he had had no conversations with the employer about taxes or anything of that sort. He testified that he didn't even know if taxes were being withheld by the employer. It's unreasonable for him to assume or presume any taxes were withheld. In fact, as Your Honor noted, how would the employer even do so without a social security number or a taxpayer identification?
So is there any circumstance where an employee should be able to, maybe not this one, because he didn't have a social security number, is there any circumstance where they should be entitled to rely on the employer?
Well, I don't think there's a presumption in the law at all, to be honest with you, Your Honor. I don't think that's what the Garcia-Lopez versus Affordable Plumbing case stands for. But again, that would call upon a knowledge of the Internal Revenue Code as to whether reporting earnings are reportable or not reportable, or what an employer's tax status is, what the appellant's tax status is. We don't know. I don't think there is a presumption in the law, is my point.
I get a paycheck every week. Money's withheld for federal income taxes. I get injured, I find out that none of that was ever reported to the government. I'm just out of luck.
Then, according to the case law, the onus is on appellant or the injured worker to make a reporting. I disagree with appellant's arguments that the appellant in this case would not have been able to do so.
Talk to us about that. Why is it not impossible? Appellant makes I think leans into that argument quite a bit, that it's impossible. He could not possibly have made this reporting until the April 15th.
Yes. Well, first of all, appellant makes an argument that he did not have the minimum earnings with which to file an income tax return under the Internal Revenue Code. This court has made it very clear that they do not read the complexities of the Internal Revenue Code in Chapter 440 or as applicable to workers' compensation. The plain, clear, and unambiguous meaning of the statute does not provide for an exception or an exemption from the reporting requirements for any reason. If the legislature intended there to be such an exemption, such as for minimum earning requirements or timing, then it would have put it in the statute. It never intended the judge of compensation claims to undertake an analysis of the Internal Revenue Code to determine whether an injured worker falls into a category of reporting or not reporting. It improperly puts the judge of compensation claims in a position to decipher the U.S. tax code as to which this court has already disavowed, as outlined in cases such as the Renee Stone case, the Dubois case, the Casey Electric case, and the University of Florida versus Bowens case.
Well, all of those are different from, so it's different to say, hey, I don't have to report this. IRS says I don't have to. Okay, so then the answer is, well, you may not have to for the IRS purposes, but you do under the statute here, so do it anyways. But that's different from the argument, I think, that appellants, and I recognize they're making that argument also, but I think it's different from the argument that it's impossible to report it.
Yes, and much has been made about the timing of reporting in this case. But, Your Honors, this court has seen these exact same facts before. In the Centimark Corporation versus Gonzalez case, there were the same facts that we have here. An undocumented worker with no social security number in the United States for 2 years was paid cash with no tax withholdings. The date of accident in that case was February 23rd, 2007. The final hearing was held on January 14th, 2008. This court reversed the judge of compensation claims finding of an average weekly wage and found that that injured worker had made no showing that he had reported for federal income tax purposes. The timing of the hearing on or before any Internal Revenue Code filing deadlines, whatever those may be, had no bearing on the court's finding in the Centimark case. And there's no evidence that anything prohibited appellant in this case from filing any kind of filing I'm not an expert in the Internal Revenue Code, neither is a judge of compensation claims, and I would hazard a guess that neither is this court or Mr. Quaresma, for even that matter. There's no evidence that he couldn't have made a quarterly reporting or a notice of payment of estimated taxes. Appellant also could have asked the judge of compensation claims for a continuance of the final hearing if it felt it needed to postpone for any reason to make a filing if that were appropriate, but appellant did not do so in this case. If the legislature intended for dates or deadlines to apply as to exceptions to reporting, then they could have done so in the statute. But this puts the judge of compensation claims in a position to decipher the U.S. tax code as to the timing of filings available, which this court, again, has already disavowed. It is not the role of this court to expand or modify the statute in the way that appellant seeks as to the timing. I disagree with the arguments about impossibility as well. I really don't think it matters. I also haven't heard what specific federal law appellant contends conflicts. Are we talking about the whole of the Internal Revenue Code? I haven't heard that argument here today. Appellant is offering his own opinion as to what the Internal Revenue Code requirements may or may not be as to his specific tax situation. And it all goes back to legislative intent. The legislature never intended to put such requirements into the statute. Judge of compensation claims does not have the power to analyze the Internal Revenue Code. In fact, this court has disapproved of that. Is a judge of compensation claims now going to have to take evidence and make findings of fact about an injured worker's tax status, the amounts and types of income they may have, whether their income meets minimum thresholds, investment income, interest income, gambling income, who knows? Self-employment, whether or not they meet the minimums. Is a judge of compensation claims going to have to make conclusions of law under the Internal Revenue Code as to whether and when a party is supposed to file or report their taxes, what minimums apply, whether there are credits or refunds? Is a judge of compensation claims also going to have to make findings of fact and conclusions of law as to an employer's tax status, the timing of their payments and reporting? There's some problems with this, Your Honors. There would be an incentive for injured workers to conceal cash income if they thought it might make them ineligible to file a tax return, thus defrauding workers' compensation and the federal government. It would also create a system that rewards indemnity benefits to an injured worker for not reporting his income for federal income tax purposes. And second, the judge of compensation claims would be put in a position to analyze and apply the Internal Revenue Code in determining whether an injured worker's earnings meet the definition of wages. And the court has previously declined to expand the judge of compensation claims responsibilities. This court, for example, in Renee Stonework versus Gonzalez, adopted the position that there is no authority to support that the legislature intended that a judge of compensation claims decipher the U.S. tax code when determining whether an injured worker reported his earnings for the IRS. Furthermore, the judge of compensation claims is not a court of general jurisdiction, nor is a judge of compensation claims expected to apply subject matter beyond that specifically conferred by the statute. The judge of compensation claims is constrained only to application of the plain meaning of 440.02 subsection 40, not application and construction of the complexities of the Internal Revenue Code. The legislature made it very simple for a judge of compensation claims to find whether a reporting was made or not. It is a yes or it is a no, to make a determination as to whether earnings meet the definition of wages. Appellant proposes indemnity benefits should be paid on earnings not reported for federal income tax purposes. And that flies in the face of and is in direct conflict with 440.02 subsection 40 and would be an unfair outcome as to any other workers who did report their earnings for federal income tax purposes. Appellant argues that somehow appellant in this case was a poor and vulnerable member of society, but the record evidence does not support that. Mr. Quaresma is university educated. He's a mechanical engineer. He worked in the industrial mechanics for 15 years before he came to the United States. He testified he came to the United States for the purpose of providing his family with something better and sent all of his earnings home to Nicaragua. Again, these are policy arguments. The workers in Renee Stone and in the Garcia Lopez versus Affordable Plumbing cases were both undocumented without Social Security numbers, and both managed to file income tax returns. And in both of those cases, this court agreed that both had made a reporting for federal income tax purposes. Your Honors, this court should affirm the judge of compensation claims' order. The judge of compensation claims got it right. The judge of compensation claims correctly applied the plain, unambiguous meaning of 440.02 subsection 40, and as intended by the legislature, applied the very simple test of whether yes, a reporting was made or no, it was not. Here, competent substantial evidence supports that it was not reported. No reporting of earnings was made for federal income tax purposes, and therefore appellant's earnings do not meet the statutory definition of wages under the statute. To do otherwise would be to go beyond the powers of this court. It would be a matter for the legislature to add, expand, or modify the statute in any way. The judge also got it right when he found no competent substantial evidence that the appellant relied on any misrepresentation or presumption, as they argue here today, and changed his position to his detriment. There is no competent substantial evidence that the employer made any misrepresentations, that the appellant relied on any of those misrepresentations or even the presumption, and there's no record evidence the appellant changed his position based on any misrepresentation or presumption. Estoppel does not apply in this case, Your Honors. And finally, the judge of compensation claims did not abuse his discretion in declining to apply the unclean hands doctrine, particularly in light of the fact that there was no competent substantial evidence to support application of the doctrine. There was no trickery or concealment or unconscionable conduct here. Therefore, this court must affirm. Thank you.
Thank you, Ms. McIntyre. If you could address the Cinemark versus Gonzalez case that appellee argues is on all fours.
In particular, with regard to which point, Your Honor?
In particular, that appellee argued that it was on all fours with this case and cited it 4 times in her brief.
Yeah, I don't think it is. First of all, they never reached the critical issue that we're here for in this case, right? They mentioned nothing at all of the impossibility of the injured worker to have reported his earnings in that case. So that was an issue that wasn't even considered in that case. While there may be some similar features in terms of Hispanic workers who were undocumented, that's about where it ends. So I don't really see in any fashion how that case controls the outcome of this case. What does control the outcome of this case, we'll agree on this point, right? Plain language of the statute. It requires simply that wages earned and reported for federal income tax purposes. Here's where the judge went wrong. He added a requirement that those wages had to be reported in the same calendar year as the final hearing or before the final hearing. Again, the legislature does not say when they have to be reported. And again, it was impossible for the injured worker here to have reported those earnings, right? It would have been a futile act. We're not asking for policy arguments, right? What we're asking Your Honors to do is consider the plain language of the statute that the legislature contains no direction whatsoever as to when the earnings have to be reported. And it only gives you reference for federal income tax. Well, that reference that it gives you for federal income tax should direct you to look at what the IRS code says about when it has to be done, right? This is not about public policy. This is about legislative intent. And the statute is very, very clear that the statute is to be construed in a way, all right, this is an edict upon you as members of this court, that you construe this law in a way that assures the quick and efficient and prompt delivery of benefits to the injured worker. It doesn't say it once that you do that, it says it twice, because it's that important, it's that foundational. And when you look at that legislative edict and you look at simply what the statute requires with no guidance as to when it must be reported, I would submit to you the alternatives are 2. Number 1, we let the injured worker go without any benefits until he can file his report his earnings for the following year, or we allow the presumption to apply, as we've argued, that the injured worker gets the presumption the employer reported those earnings until such time as he is allowed under federal law to report that income the following year by April 15th. So, Your Honors, we would respectfully ask that you reverse and remand consistent with what the request for relief that was contained in our brief at the conclusion section. Thank you.
Thank you very much. All right, that concludes our OA docket for this afternoon. We're adjourned.
All rise.
Good to see you. Always a pleasure.
Yeah, we'll see you,
See you in a couple weeks, yeah. We'll be see you in Orlando.
Yep.
August, like usual.
Yeah. Have a good day now.
So much. Take care.
Hey, see you now. Mute those mics.